After the stalwarts in the system, from the bar and the bench, addressing for almost 2.5 days, I'm almost the last batsman in the Greece. I'm conscious of the fact that everyone is in a mood to log out and thinking of their return journeys and planning for regular professional work before the course with all vigor after the summer vacation. The warm-up you had for the 3 days here, before entering into the actual crease in the court field, will be helpful to all ends, not merely to the athletes, even to the courts. The same is going to be helpful. The thought of arranging the program just before reopening and leaving 1 day break is really laudable. Particularly the script of the program and the topics selected, including the players from both ends, creating a good mood and good environment involving enrichment on various aspects, generating inspiration to work with all commitment. It's highly difficult for me and my co-panelists, being the lost players on the field, to maintain the tempo the earlier speakers maintained from this dais. Yet we will try. Further, it is difficult to hold and keep all of you attentive during the last technical session, more so when you are waiting for valedictory session and also delicious dinners and lunch, etc. you are going to have. And the presence of attractive personalities like Justice Ravi Garu, the son of the soil, and the others, the professor, Vice Chancellor of University, Surya Prakash Garu, Dwarkanath Reddy Garu, Chairman, who has been, of course, for all these days, the other team, Krishnamohan Garu, Vice Chairman, and other members of the board council. Anyway, having been asked to discharge the pious responsibility of sharing certain thoughts with you all, we are before you with all the enthusiasm to share something we know, but to learn more from you all. I am told that there will be interactive session even and the question hour also, and we will be asking something and we will be sharing something, whatever we know, either the innocence, intelligence, ignorance, whatever it is, all of us are going to share and have something productive out of our discussion. I take the privilege of presenting my co-panelist, Sri Osani Venkateswara Garu. Namaste, sir. Senior Advocate, former Public Prosecutor, Sri Y. Nagareddy Garu. Of course, they are already introduced and presented. With the permission of my co-panelists and the Presidium, I proceed with my further presentation with a caveat that my team of co-panelists are always at liberty to intervene wherever they want to supplement and add anything. Now, probably, I will be walking around with the permission of all of you and the Presidium. Before going to actual thing, one thing I have forgotten to add, of course, advisory. Brother Chinnaset Raju, the district judge, post district judge. And he was kind enough in adding that if something is there to be corrected, I may have to correct. It's not a question of correction, it's always adding something. Hope I am audible to all of you. Lost. Audible, sir? Not audible.
మైక్ దగ్గర పెట్టాలి. ఇది కాలర్కి పెట్టి కాలర్ మైక్.
Hope now it is fine.
Yes, sir.
Nice of you. Repeating the concerns and thanks to host district, the bar of host district and the district judge of the Visakhapatnam, I will proceed further. Only thing I want to supplement, because the liberty is given by my brother, as to conflict between the judgment law and the statute law, what is to be. Of course, it has become the practice and it is invoked that we look at the judgment law and we follow immediately because it is ready to eat, ready to use, ready made. After checking out something and after working out on thing, we will get it, so we use it, and that is but however, see the sources of law, because many law students are there. The sources of law is more reliable and more authenticated source of law is the statute. Code judgment law, precedent is a second source. And wherever it is a question of interpretation, whether done in consonance with the statute, then probably for interpretation purpose, whether how it is interpreted, to understand the interpretation process, we look at the judgment law, except on that, adding of that, nothing to be added from what my brother said while speaking earlier. Now, coming to the topic proper, for which we are here. First July 2024, new criminal laws. FIR and charge sheet are the subjects now in specific we are going to touch upon, and the other of course is a ocean. If we go, we can't come out. I am conscious of the time constraint, and the discipline my brother Chinapsit Raju followed is that although the train started late, he could complete it on time, and our train started right time. If I cross the time, probably I will not be doing justice. That I will try to do. Even if I exceed, I think you may bear it. I am sure that we will not exceed. We will try to be on time. Now, among the law students, anybody first year to third year? Most law students, only advocates. Junior advocates, 1 to 3 years standing, below 3 years standing. Very good. Oh, fine. One of you, can you please stand? 3 statute names without.
BSS.
No, I want full form.
भारतीय न्याय संहिता.
न्याय संहिता. Next other one.
भारतीय नागरिक सुरक्षा संहिता.
Fine.
भारतीय साक्ष्य अधिनियम.
Wonderful. So, first learning of the name, and there is a lot of difficulty in just chanting the name. We have accustomed to IPC, Evidence Act, and CRPC. And abbreviational use of the statute name, for that also a judgment was necessary. Precedents, we depend on the precedent that whether Indian Penal Code is to be used as IPC, whether Criminal Procedure Code is to be termed as a CRPC, whether BNSS is to be used or Bharatiya Nagarika Suraksha Samhita is to be used. For that, High Court had to set. High Court said, after High Court saying that you can use it BNSS, you can use BS, now it has become. So, let us try to come out of that kind of things. After all, it is just for the communication purpose we use it, and that's one thing. Fine. Now, this kind of new laws coming in, is it for the first time in the century? Is it for the first time in the world history? Many times, many new laws have come. As far as CPC is concerned, new laws, amendments have come. Completely repealing has taken place and new law has come. As far as the CRPC also, whether we had experience of giving go by to old one and getting new one? Can anybody help me in, was there such experience? Whether she completely CRPC can and no CRPC has come? Anybody can help me? Is it only for the first time BNSS is coming and CRPC washed out, and earlier was there no such experience?
There used to be amendments.
Only amendments you say. complete new thing coming or substantial changes at least have come? Are you sure? What was the earlier code of criminal procedure?
Prior to 1973.
Prior to 1973. Now BNSS, prior to BNSS, 1973 CRPC. Prior to 1973 CRPC, what was there? Wonderful. 1898. So 1898 has gone and 1973 has come. Like how 1973 has come and BNSS has come. Now, are we scared of BNSS? Are we afraid of BNSS coming into field? If at all the fear is there, on what point the fear is?
We are habituated with the
Number of sections. 302, 302, 302, 375, 375, 370. Now 302 has gone somewhere 127, some other section has come. That is the only difference. The only number is changed. Same person, same ingredients, same thing. Only number tag, coat alone is changed. Same Sharma, now wearing this full coat, probably may wear half coat or may wear full gown. That is only the difference.
Same
person is same. Almost the principle is the same. So that is it. So if at all there is any worry in our mind that something absolutely has, we are in new planet, don't be afraid of that. Same thing is there, only the color is changed and the coat is changed. That's one thing. So now the coat is changed, whether it will fit in 42, 44, 40, XL, double XL, how is it to be fit? So it will certainly fit. Only minor adjustments and alterations have taken place. That's all. We have to accustom to the changes, then it will be very easy. Then this adjustment process, how it has taken place in 1974, 1973 CRPC has come after 1898 CRPC, 1973 CRPC has come. 1973 CRPC, there are also many differences, many changes have taken place. Prior to 1973, there was a committal. In the committal, there was a detailed inquiry. The evidence is to be collected, evidence is to be appreciated, and detailed cross-examination was there, everything was there. There was revision against revision in 1898 CRPC. Revision against revision. Revisional jurisdiction was there to the district court, session court from the magistracy, and on that again the revision was to the high court. How many revisions are one at one time? There is consuming lot of time. Let there be only one revision. If the revision is there by the district court, let there be no revision. Is what he brought, a change brought in 1973, which was there in 1898. How that was addressed during 1973 to 78 or 1980 by the Indian judiciary? If we look, now the same thing now we can follow. Brother was referred to case law. So the case law of the year 1973 to 1980 with regard to interpretation of the CRPC 1973 with reference to 1898 CRPC, if we see the interpretation process has to change, the same policy, same principle, same ideology we can follow now also while adopting BNSS. Am I confusing or am I confused? Will you agree with me? Am I clear? Is this something stupid? Yes. No, it's reasonable. Okay, I'm happy, but it's reasonable. Fine. Now, what is the logic behind that? When 1898 Act has gone, 1973 Act has come, whether 1898 Act also can be seen, whether when BNSS has come, whether CRPC 1973 is again, whether still that can be looked into. If I say that yes, still that can be looked into, will you laugh at me, will you accept? BNSS has come in the place of CRPC. I say that even CRPC has to be now looked at. ఇప్పుడు కూడా దాని 1973 CRPC you have to look and you have to follow. If I say, will you accept or will you not accept?
Accept.
You will not accept.
Accept.
How many will accept? I will not accept. Accept conditionally. Accept conditionally. So unconditional acceptance is not there. Conditional acceptance is there. And what condition you are now? We are on change. First, my topic heading is that we are in change. Change how is to be understood. For that purpose, I am doing all this exercise. So, conditionally, we can look into even the earlier one. So, what is that condition? For certain purposes it can be looked into, for certain purposes it cannot be looked into. What are that purposes? Pending. So far as the pending matters are concerned, earlier thing, so far as the new is concerned, only new. What is the basis for this distinction? పెండింగ్ అది కొత్త దానికి మేము 2 పుస్తకాలు మెయింటైన్ చేయాలా, లైబ్రరీలో ఆల్రెడీ నిండిపోయినాయి, ప్లేసే లేదు, లైబ్రరీలో లేదు. అదే వాళ్ళు ఒకటి చదవడానికి తలనొప్పి, ఎగ్జామ్ ఒకటి రాయడానికి తలనొప్పి, జేసీజీ ఎగ్జామ్ రాయాలన్నా, డిస్ట్రిక్ట్ జడ్జి ఎగ్జామ్ రాయాలన్నా, వీ హ్యావ్ టు ప్రిపేర్ అండ్ లుక్ ఇన్ టు సో మెనీ థింగ్స్. దెన్ యు ఆర్ ఆస్కింగ్ us to go through 2. What is the fun and what is the logic in looking at this 2? What is the statutory base? What is the logical or legal base for that? Can you refer absolute or can you show your finger at particular statute or particular provision of law for this preposition that we have to look at both? 531. Okay, BNSS 531 is one thing. Even before going to 531, are there any other principles that guide us to look at the existing one? Can you guide me? Can you take me to any particular provision of law, particular legal principle for that purpose? Wonderful. The doctrine of prospective application, the doctrine of retrospective application. Again, you are referring me, you are taking me to doctrine and principle only. My emphasis on the provision. My request is that can you place or can you drive me to any particular provision?
Yeah.
Article 20 clause 1 of the Constitution, subject of my brother. You are referring that the constitutional perspective also.
Yes, sir. Article 20 clause 1.
Yes,
No
ex post facto law. Ex post facto law to a fact that has occasion, that has happened. A law that has come into force subsequent to a fact cannot be applied. A law is ex post facto, cannot be applied to a fact already happened. That is protected, that cannot be applied is what? The constitutional protection under Article 20 clause 1. Fine.
For criminal laws, sir.
Fine. Okay, I will come to the other end also. Whether it is only for criminal law or any other law. I say that for other law also there is a principle. Can any one of you take me to that provision which guides us to look at any law, not mere criminal law? Hope 1 to 3 years.
Constitution of
Any other? 3 to 10 years.
Constitution
Any
of
other?
India. Constitution of India.
Constitution of India, just now we are discussing about 20 class 3, 20 class 1. Have you heard of General Classes Act? General Class Act, wonderful. General Class Act, any particular provision, can you drive me? Section 6 of General Classes Act, if you see, you please have a mantra, a permanent mantra is Section 6 of General Classes Act in respect of adopting and applying and understanding the change in law is the Section 6 of General Class Act. Even in the absence of any particular provision, brother was referring to 531 of BNSS. 531 of BNSS is saved 1973 CRPC. Okay. Even if 531 was not there, even the legislature slept over or did not think of having that 531, still General Classes Act Section 6 would say that whenever any new law is enacted, it will not disturb, it will not take away any right, obligation created under the existing law. The obligations will continue to exist, the rights continues to exist is what the spirit of Section 6 of General Classes Act. This is one thing. So, backdrop is General Classes Act, Article 20 Constitution. In this background, any law, change in law is to be understood. Fine. Next. What to? Now, 531, what is the head of 531? What is the heading of 531?
Repeal and savings.
Repeal and savings. Do you find the same analogous provision in BNS 358? 358? Is it 358? Is it 358? Do you find it on Indian, this Bharatiya Saksha Adhiniyamam, made it 170? So all the three enactments, BSA, BNSS, BNS are having a provision dealing with the provision of repealing and saving. This provision repealing and saving, if you see, each sub-provision under these three provisions, 351, 358, 531 and 170, these three acts, you see General Class Act 6 and 6 of General Class Act, 99% of the language is the same. Section 6 of General Class Act language, 351 language, 531 language, 358 language and 170 language is almost more than 95% is the replica is the same. So repealing and savings, the importance of repealing and savings, whenever you read any statute, firstly we have to look at, we have to look into, we have to bear in mind, we must be mindful of repealings and savings. What is repealed, what is saved? What is repealed, what is saved? ఇంట్లోకి రాగానే కొత్త కోడలు వస్తుంది, కొన్ని అత్త దగ్గర నేర్చుకోమ్మా, కొన్ని నువ్వు పనులు నువ్వు చేయమ్మా అని ఎట్లా చెప్తారో, కొత్త ప్రొవిజన్స్ కొన్ని నువ్వు పని చేయమ్మా, కొన్ని పాత అత్తగారి దగ్గర నేను నేర్చుకో అని చెప్పినట్టు పాత ప్రొవిజన్స్ కూడా అప్లై అవుతాయి అని రిపీలింగ్ అంటే సేవింగ్ ఈజ్ అత్తగారిని, రిపీలింగ్ అత్తగారిని పక్కన పెట్టి కొత్త కోడలు మొత్తం పని అప్ప చెప్పడం. Very simple. So we need to keep this ideology, this principle. Then if we read a statute, we can make use of it to a maximum tune. This is one principle. Next, while reading any statute, every statute generally will have four components. Statement of reasons and objectives, the purpose for which a statute is enacted. Secondly, the definition clause. The words, important and technical words that are used in a statute, how they are to be understood. Thirdly, the body, for what exactly it is dealing with. And lastly, repealing and savings. The last part, repealing and savings, is hard according to me. If you are thorough with that, and you will be making good use of the statute. So this is one tip with which we need to go. And the importance of repealing and savings is such. So this is all the provisions you can read. Okay. Consequences of repealing. Common law doctrine. This whatever asset is there in the slides, and that will be said, no issue. Section 6 of General Class Act. What it says. 358 BNSS. Then 531 of BNSS. Okay, repealing is not for first time. Earlier also was there, 1973 CRPC, 484. Earlier section 484 of CRPC was there earlier. When 1973 Act has come, 484 was there, which is similar to 531. How 484 was interpreted in the transitional stage between 1973 to 1980, judges case law, referring of case law, if you want to refer the case law, how the 531 is to be applied or interpreted, please refer how 484 was interpreted when the recent days 73 to 80. The principle and analogy with which it can be interpreted, you could know. For that purpose, this is relevant. Next, constitutional perspective is Article 20 Constitution. Doctrine of beneficial construction. Here I take a pause. Now, old law is to be applied, new law cannot be applied. Why? Where a right is created or obligation is created, that our right or obligation cannot be taken out. So at the time of commission of the offence, 3 years punishment is prescribed. Subsequently, 3 years punishment is increased to 5 years. Take 354 of IPC for that matter, outraging of modesty. At one stage the 5 years was there, at one stage the punishment pattern has somehow, and compoundability also changed due to change of legislation, and state amendments were also affected. In one state that it is compoundable, in another state it is not compoundable. Repugnancy between the two things, how it is to be understood, one aspect. Now, as at the date of the commission of the offence, if the punishment is something, and subsequently it is increased, will you accept that increased punishment is to be? No. Fortunately, it is decreased. It was earlier 5 years punishment, now we made 3 years punishment is. The legislature has taken the view that punishment, offense anta punishment akkarledu. 3 years punishment is enough. The legislature takes a stand. And the law is amended, making it a lesser punishment. Now, can you claim the benefit or can't you claim the benefit? My question. How many of you say that? How many of you say that higher punishment is to be imposed despite the decrease? Liar alagani cheptaru sir repu podduna meer judge ki enquestar not. Now we are not lawyers and judges now. We are just academicians. Just we are discussing academics. How many of you will agree that because the law on the date of commission of offence, the law and the fact has occurred and the law is there and that occurrence of particular fact, that law is to be applied is what Article 20 Constitution says, 21 says. Then can you say that no, the decrease, please decrease? Have you read any provisions under the BNS that where the punishment is reduced? If not reduced, don't ask me what are the provisions. It's a homework. Morning, Dwarkanath Reddy Garu was referring to what spoken from here and form into teams and discuss what is the point right and just churn it so that the academic churning will be there and some kind of cheese will come out of it is what the message of the president. So, this is a homework for all of you. So, fine. So now, I will not leave that question. Can you ask for lesser punishment?
Was not decreased, but community service was included for few of offences.
Okay, community service is a kind of thing. I appreciate.
Different type of
fine.
Instead of fine or community service.
Okay. So I am on the point. Is a punishment pattern itself is changed as far as the community service is concerned. I am on the point if a lesser punishment is imposed. Whether the lesser punishment can be brought into picture, can be demanded of.
You are saying can the lesser punishment be prospective effect?
Retrospective effect. Retrospective. My question is whether lesser punishment can have retrospective effect is my question. How many of you say no? How many of you say yes? Any no's? I think noto. Probably everybody will rush to have noto. I don't know. Sir, what is your stand?
What I say, this is also like
no arrest. I don't want any explanation. Yes or no?
No.
No means only higher punishment is to be imposed.
Yes, as on the date what he has committed. It is a contract with the state.
Or anybody will decide from him.
Yes, sir.
So dissent is there. So how are you going to dissent from him that a lesser punishment is to be imposed? How do you justify that the lesser punishment is to be imposed?
Sir, punishment is benefit.
Wonderful. So beneficial construction of the legislature, always the Supreme Court judgments, number of cases said that you please search, don't ask me a citation, just I wrote down citations, there are citations. I don't have time. They are with me to search out, I have to do that. But just throwing a thought for igniting your minds and thought process. Legislative benevolence, please capture the word. Legislative benevolence. Legislature ఎక్కడైతే క్షమ చూపించిందో ఆ క్షమను ప్రతి ముద్దాయి కోరుకోవడానికి అర్హుడే. So the legislative benevolence, benefit of legislative benevolence and beneficial construction can always be demanded and it can be asked whether they demand or not. The court is bound to extend the benevolence which is contemplated by the legislature. This is another philosophy of the law. Part 3. So now lightning round. Instead of heavy lightning round. So I was under the impression that some law students are also there. Some questions are there. Later I am clarified. I am thankful. So fine, forget about it. All of you are practicing in trial courts only. High court, forget about high court, trial court. Some good number are there and from trial courts only. Majority are there from the trial courts only. Very good. Magistrate courts. డిస్ట్రిక్ట్ కోర్ట్, సెషన్స్ కోర్ట్ కాదు, మ్యాజిస్ట్రేట్ కోర్ట్. ఐఎమ్ ప్యూర్లీ ఆన్ మ్యాజిస్ట్రేట్ కోర్ట్. చాలా తక్కువ 20% కనిపిస్తాను. మ్యాజిస్ట్రేట్ అండ్ సెషన్స్ కోర్టు రెండు ట్రయల్ కోర్ట్సే, బట్ మ్యాజిస్ట్రేట్ కోర్ట్ అనేటప్పటికి చేతులు కొద్దిగా తగ్గుతాం. So lot of law, lot of cry, lot of need and lot of necessity is there in magistrate courts only. Kindly don't have any a lesser feel for a magistrate court. More need is there in the magistrate court. So I request and I appeal to all of you, embrace as far as possible the magistracy also, so that you want to have any correction and sound foundation, it can be from the magistracy. From there the revision to the sessions court, from there to the high court, the matters who do come. So try to, next, last I will withdraw this question. So now, who are on courts, all of you want to continue in the courts, or you are searching for judges jobs, prosecution jobs, company laws, corporate side, litigation లోనే ఉండాలనుకుంటున్నారో ఎక్కడన్నా బయటకు వెళ్ళిపోవాలనుకుంటారా? Any one of you who are searching out other opportunities can, just for my help. Nobody? Ever unnara? You want to go for corporate or other than litigation?
You interviews, sir.
Other than litigation. What made you to go for other than litigation?
Already yesterday we had a discussion.
I am sorry. I dropped that question. I dropped that question. The waste of time. So my worry or my concern and my request is don't quit. Dropout is the biggest menace for the system. Good brains and good things must continue and have a consistency, and then the profession will have its own glory. Don't drop out. Never drop out. Patience and waiting will pay you. Only thing availability, only thing you are available. Amma annam పెడుతుంది, నువ్వు అక్కడే ఉండు. ఉంటే అన్నం పెడుతుంది, నువ్వు వెళ్ళిపోతే అన్నం చిక్కదు. Now 154 FIR, the subject academic, the సమస్య అకాడమీలో చేసిన ఇబ్బంది వల్ల అసలు దానికి రావడానికి ఇంతసేపు పట్టింది, అరగంట పట్టింది. సో FIR అనేది మన సబ్జెక్ట్ కదా, FIR 154 కదా. 154 ఆబ్జెక్టివ్ ఏమి? 154 ఆబ్జెక్టివ్ ఏమి? అక్కడే రాష్ట్రం. So set the criminal law into motion. The provision 154 next time is to set the criminal law into motion. So fine, to set the criminal law into motion. Who will set the criminal law into motion? Who will set the criminal law into motion? Police will set the criminal law into motion, or anybody will set the
Complainant.
Complainant is the right word, or any other right word is to be used? 100%. So we are in the stage of improvising and fine tune. So the words and language also, let us be as nearer as possible to the statute, and let us be as nearer as to the form that are prescribed. It makes no difference, but it reflects the beauty of your expression. So informant is the appropriate word. So you will send the criminal law into motion. Why? Whether FIR shall be signed in every case or need not be signed.
Signed.
అన్నిట్లో సైన్ చేయాలా?
FIR should be signed.
నీడ్ నాట్ బి సైన్డ్ ఎవరన్నా చేతులు ఎత్తండి. ఎందుకు ఎప్పుడు? ఎందుకు ఎప్పుడు? సమ్ టైమ్స్ ఫోన్లో చెప్తారు కాబట్టి సైన్ చేయలేదు, ఓకే. అప్పుడు కూడా సైన్ అప్పటికి అక్కర్లేదా? అప్పటికి అక్కర్లేదా? అప్పటికి అక్కర్లేదు, తర్వాత చేయాలి. ఎప్పటికీ అక్కర్లేవు ఏమైనా ఉన్నాయా? ఎప్పటికీ అక్కర్లేదు అనేది ఏమైనా ఉన్నాయా? అక్కరుందా లేదా అంటే అక్కరుంది ఖచ్చితంగా. అప్పటికి అక్కర్లేదు, తర్వాత అక్కర్కుంది, ఒక సిచ్యువేషన్ వచ్చింది. ఎప్పటికీ అక్కర్లేదైతే లేదు కదా, లేనంటనా?
విక్టిమ్ కంప్లైంట్
అంతగా రాదు.
ప్రశ్న
వేయచ్చు, చేయగొట్టేశాడు, తో కాలింగ్ ప్రశ్న వేయచ్చు. సో సమ్ కైండ్ ఆఫ్ మార్క్స్ షల్ బి దేర్. సో అప్పుడు సైన్ అనేది ఇట్ గివ్స్ అన్ అథెంటిసిటీ. సైన్ అనేది కూడా ఉండాలి. మీరు క్రాస్ ఎగ్జామినేషన్ చేసినప్పుడు సైన్ చేశారా లేదా? సైన్ చేయకుండా రిజిస్టరే కాదు. ఎవరు సైన్ చేశారు అనేది ఇంపార్టెంట్. హూ హ్యాస్ టు సైన్? ఇన్ఫర్మేట్ హ్యాస్ టు సైన్. అంతేనా? పోలీస్ సైన్ చేయాలా? ఇన్ఫర్మేట్ వేస్తేనా? ఇన్ఫర్మేట్ సైన్ చేయాలి. అన్ని కేసుల్లో ఇన్ఫర్మేట్ సైన్ చేయాలా? ఎక్కడైనా ఇన్ఫర్మేట్ కాకుండా వేరే వాళ్ళు సైన్ చేయొచ్చా? పోలీస్ ఆఫీసర్ can be informant. He is an informant, so he is not signing. No problem. He is signing. He is an informant. He is signing. No problem. Other than informant signing circumstances, are there any circumstances other than informant can sign.
Yes, sir.
Minors. Minor.
Child.
Wonderful.
Indigent
Third
person.
అసలు పరిస్థితి informant లేదు. Next.
Indigent person.
Indigent ఆ? Indigent కే మీరు సంతకం చేయాలి.
Sorry, not lunatic, idiot.
Okay. Insane person. Not indigent, insane person. So insane person ఉన్నప్పుడు వాళ్ళకి ఏదైనా జరిగితే anybody whoever is giving information on behalf of that person can sign. And he is not indigent, he is not insane, he is the same, not minor, but on behalf of somebody, whether only victim has to sign or anybody can sign, anybody can give the information.
Anybody.
Anybody can give the information. So it is not always necessary that only victim has to give information. Anybody can give information. If the victim gives information, authenticity will be more. That's all. So next. Legal and logical issues. Purpose of setting the criminal law into motion. Do you find any other provision in CRPC which deals with setting the criminal law into motion? The complaint is one thing.
Sumoto.
Sumoto, of course, the judge has knowledge, he recognizes if it is committed in his presence, in his court, he recognizes that's a different thing. Magistrate, not judge. I am on the point, setting the criminal law into motion, any other provision of law.
Email.
Section 39 of children. Section 39 of CRPC says that every person who is aware of a commission of a cognizable case has a duty and obligation to report. This is referable to 51A duty, fundamental duties కూడా రెఫర్ చేయగలిగిన కాన్స్టిట్యూషనల్ పర్స్పెక్టివ్లో రెఫర్ చేయగలిగినటువంటి ప్రొవిజన్ వీరు రిపోర్ట్ చేయాలి. చేయకపోతే మీరు తప్పు, యు ఆర్ కన్సీలింగ్, సమ్టైమ్స్ యు హ్యావ్ కన్సీల్డ్ ఫ్యాబ్రికేషన్ 201, 202, 203 లోకి కూడా వచ్చి దూరం వెళ్తాయి. So it is an obligation on the part of the citizen to report about the crime, and everyone is competent. Who is competent to set the criminal law into motion is every person who is aware of the commission of cognizable offence is competent to set the criminal law into motion. It is not mere competency. It is as a duty. It is as an obligation. It is a statutory obligation to report about the knowledge, that information, transmission of information to police. బాగుంది. నువ్వేమో ignorance of law is not an excuse for the citizen. When the offence is in your knowledge, you have to inform. Okay, fine. Okay, the organizers, my appeal, whenever you want me to shut, I will shut down.
No, sir.
Okay, fine. No. So I welcome on behalf of the organizers, Honorable Justice Sharma Ravi Garu, sir. Namaste and good afternoon, Brother Justice Ravi Garu. No, it's my pleasure.
Sorry to disturb you all.
It's our pleasure, sir. In fact, we are emboldened. Okay, please, sir, please.
Interesting subject. We can have more than 4:30, after 4:30 we can have.
Sir, whatever time, then probably my brothers are also, the co-panelists are also there. They will say something. Okay, friends, please take care. Please take your respective seats. Friends, please take your respective seats. Almost maximum I may take for another 15 minutes, and my co-panelists will, and I hope whenever necessary I will try to add something wherever I feel like. So now we are on FIR. I was referring to the obligation of the citizen under section 39 of the CRPC, and it's always as well as right, not only a right but also an obligation to set the criminal law into motion. The moment you set the criminal law into motion, it will be set in the form of FIR. FIR is given. Ignorance of law is not an excuse. There is duty, fundamental duty is there, statutory duty is there. If you report, they don't register. They don't register. Whether 154 speaks of anything as to the obligation on the part of the state to register. Obligation for the citizen to give complaint is recognized under 39 and it is there, we all agree. And obligation on the part of the police, obligation on the part of the investigating agency or the police is there or not. It is certainly there under 154, they have to register, is fine. It is mere, the obligation under 154, is there anything else added to that here? I will request all of you to see, go through thoroughly. It is running into 120 paragraphs. Lalita Kumari case is a classic case. It has driven, and the sea change is there in the jurisprudence related to the registration of FIR, and a lot of mandates are given by the Honorable Supreme Court in Lalita Kumari 1 and Lalita Kumari 2. Lalita Kumari 1 was of the 2 judges bench, and the matter come before the 5 judges bench in Lalita Kumari 2. Lalita Kumari 2 guidelines are such, registration of FIR is compulsory. In the judgment, if you go through, you will come across, you will see, the what I have referred to just now is also discussed. You are asking a citizen to compulsorily give report, and you are not registering, and you are registering with some speed in cases, not registering with the same speed in another cases. Why are you that speed? Why are you that slow? Therefore, it is must and should for you to register the FIR whenever the complaint is given by the rider is that it must disclose commission of a cognizable offence. It must disclose the commission of a cognizable offence. What is cognizable offence? I don't go deep because the time is running short. Bandaguttu, Kondaguttu, where the police officer can arrest without warrant is a cognizable offence. Broadly, 2 years and above punishment cases are there. They are cognizable offences. So, where it discloses the commission, then when you can say that it is disclosing, when you can say that it is not disclosing. Again the question. మనం ఆల్వేస్ మనకు జడ్జ్మెంట్ కావాలి, ఒక సర్కమ్స్టాన్స్ కావాలి, ఒక ఇల్లస్ట్రేషన్ కావాలి. ఇల్లస్ట్రేషన్ ఉంటే కానీ వీ డోంట్ సాటిస్ఫై. Laws enacted during the British period, if you see old laws, every section will have an illustration, 5 or 6 illustrations dealing with the different contexts and circumstances for which the law is made. Now it is not there. However, we have to. So, where it is disclosing cognizable offence, where it is not disclosing cognizable offence. I will give you an illustration. It's only for classroom purpose, don't cite anywhere. ఏం బయటకి ఇక్కడ పత్రికల్లోకి ఏం అవసరం లేదు, మనం క్లాస్ అనుకుందాం ఉదాహరణ. బట్ ఐఎమ్ గైడెడ్ బై ది సుప్రీం కోర్ట్ జడ్జ్మెంట్. ఒక సిచ్యువేషన్లో ఒక వ్యక్తి, ఎవరెందుకు నేనే, నా ఫ్రెండ్ పాకిస్తాన్లో ఉన్నాడు. పాకిస్తాన్లో ఉన్నటువంటి ఫ్రెండ్కు ఆగస్ట్ 14 రోజు ఒక మెసేజ్ పంపిస్తాను. హ్యాపీ ఇండిపెండెన్స్ డే పాకిస్తాన్. Happy Independence Day of Pakistan. Happy Independence Day of India is August 15. August 14th is the Independence Day of Pakistan. So, I give a message that Happy Independence Day of Pakistan. Let us celebrate. And the things happening here are not that comfortable. And the obligation of 370 is one such circumstance I am feeling worried is also my message. What it is said, the message said. Then basing on that, FIR is registered. Now the offence is a seditious offence, maybe 153A of recent, or whatever the provision of seditious is what the allegation made against me, one of the persons who got that message, who had access to that message. Maybe it is a public video or WhatsApp video which I have sent to group in which my Pakistani friend is also a group member. I sent to that message. Basing on that message, FIR is registered. Now do you say that there is a cognizable offence? These things likely to happen in the course of a journey. If you see a decided case law, in the similar circumstance, it is said that expressing good wishes to another national who will have a friendly gesture does not amount to any provocating the animosity among the other thing or hatred against your nation. After all, you are greeting the other nation who are your friend. It does not amount to any hatred. It is not disnational exhibition of your anti-national interest is not there in this message. It is the first observation. Second observation, that abrogation of 370 is not happy with me, I am not happy with abrogation, and the process in which it is done is what the statement. Whether this will amount to provocating or promoting any kind of animosity is the next question. But it also the observation is there by the Supreme Court that no, if do does not amount to, it is a freedom of speech and expression guaranteed under Article 19, Class 1 of the Constitution. So after all, it is an opinion expressed. Democracy expects the freedom of expression. Under the freedom of speech and expression, he has expressed that there exists no element and quashing of FIR had been done. Fine. Come to the illustration B. I'll come to next illustration. ఇలాంటి సినారియోలో ఒక పోయం రాస్తాడు ఒక కవి. నేను మాట్లాడితే రాజ్యానికి కోపం వస్తుంది, నా రాజ్యం కోపపడింది నా మాటలకు అంటే నేను కోపాన్ని కూడా సంతోషంగా తీసుకుంటాను, నేను కష్టాన్ని కూడా సంతోషంగా తీసుకుంటాను. నేను, నా కుటుంబ సభ్యులు, నా మిత్రులు, నా ఇష్టమైన వాళ్ళ యొక్క రక్తము రాజ్యానికి ఇష్టమైనట్టయితే అది దారపోయడానికి, నా స్వతంత్రమైన భావాలు వెదజల్లడానికి నేను ఇష్టము అని ఒక కవిత రాస్తాడు. ఈ కవిత రాజ్యానికి వ్యతిరేకంగా ఉందంటారా లేదంటారా? Say for example, a case is registered that it is an expressing of anti-national tendency and anti-communal tendencies are there expressed in this అని చెప్తారు. చెప్తే do you agree? సున్నితమైన విషయము, గంభీరమైన విషయము, కానీ జరుగుతాయి. అప్పుడు మీరు యు ఆర్ ఇన్ డిఫెండింగ్ ఫీల్డ్. నేను ఇక్కడ చెప్పింది అక్కడ కూర్చుంటే బయటింగ్ అని నేను చెప్పట్లేదు, ఊరికి అకాడమిక్ డిస్కషన్ కోసం చెప్తున్నాను. ఐ గో బై విత్ మెటీరియల్. సో ది మెటీరియల్ ఇన్ సింపుల్ ఇస్ దిస్. ఇన్ దిస్ simple material, what would be your response as far as the registration of FIR and questioning of FIR and quashment of FIR and judicial intervention, scope for judicial intervention, all these aspects do come. Fine. So this is also a covered judgment recently 2025. These two judgments are by Honorable Justice Oka. రెండింటిలో కూడా వారు ఏం చెప్పారంటే నో, యూ కెనాట్ క్రాష్. ఇప్పుడు దాని ఛాలెంజ్ ఇది. ఇలాంటి సిచ్యువేషన్ వచ్చేప్పుడు ఈ సైటేషన్ మీరు బేస్ చేసుకొని జడ్జి గారు దాన్ని ఆర్గ్యూ చేస్తే కనీసం బెయిల్ వస్తుందా, రిమాండ్ను అపోజ్ చేయగలరా ఈ జడ్జిమెంట్ను బేస్ చేసుకొని ఇలా సర్కమ్స్టాన్స్ ఉన్నప్పుడు చేయకూడదా? చెప్తే మీరేం చేస్తారో, మా మ్యాజిస్ట్రేట్స్ ఏం చేస్తారో మేము చూసుకుంటాం, మా అకాడమీలో మేము చూసుకుంటాం, బెంచీలో చూసుకుంటాం, ఒకవేళ బెంచీలు ఏమైనా చేస్తే పైన ఏం చేస్తారో అనేది చేస్తారు. బట్ యాజ్ అన్ అడ్వకేట్ ఇవి ఎక్విప్ అయ్యి, ఈ సైటేషన్స్ ఎక్విప్ అయ్యి ఈ జడ్జిమెంట్లోనూ ఇన్ కాంట్రడిక్షన్ టు ది స్టాట్యూటరీ ప్రొవిజన్, ఆర్ యూ రెడీ టు పాయింట్ ఫింగర్ అవుట్, ఆర్గ్యూ, present and question? It is my question. Please be ready. Please equip yourself. But don't be result oriented, effort oriented. Detach the effort oriented approach will give you the result at least in due course, if not immediately. It will certainly give, lay a foundation how the approach is what my appeal. So go through these judgments of Honorable Justice Oka. Now setting the criminal law into motion. Now it's only in respect of cognizable offence or non-cognizable offence లో కూడా FIR రిజిస్టర్ చేయొచ్చా? Non-cognizable offence లో FIR ఉందా? Is there any scope for registration of FIR in non-cognizable offence?
There shall be some other form.
What is the other way out for non-cognizable offence? Private complaint. So the situation is that even if a non-cognizable offence is informed to the police need not register the FIR. For registration of FIR, permission of the magistrate is necessary. You see 155 of CRPC, they have to seek the permission. Earlier the situation was that whenever information about non-cognizable offence is given, the court magistrate has to refer the information to the magistrate, and magistrate has to interview the permission. After permission of the magistrate, the FIR is to be registered by the police and investigation is to be done. Is what in respect of non-cognizable offences the earlier situation. For the speed of the name, I'm sorry. Hope the track is going on.
Yes, sir.
Fine. So, Khani, after the Supreme Court intervention and interpretation of the law, they are complaining about the lawlessness. It is the offence itself according to the non-cognizable lesser one. If you say that it has to go, how much of hurdles, how many problems, how many intermediaries will be there and how much of hand vetting is necessary in the process, you have to imagine. So imagining all the things, it is not the job of the informant to go to the magistrate to have the permissions, etc. You police send it to the magistrate and get this nod in turn and then register is what the guidance is. So now the obligation is referring the matter, not referring the information. They will take, then what is that they have to do? They have to do is they have to enter the information in somewhere. Where is that somewhere? Can anybody? Huh? Wonderful. General title. So GD is the concept, entering into GD. Is there any other document equal to GD maintained by police? Public property? Anybody can help me? FIR register. FIR register will be there, FIRs will be there, FIR register will be there, and GD will be there. GD and FIR, is there any difference between GD and FIR? What is the difference, sir? Difference between the GD and FIR.
GD will record every inward
GD will have information of every
inward paper.
every information, every inward, whatever is received. Phone వచ్చింది, టెలిగ్రామ్ వచ్చింది, ఎవడో మాట్లాడుకుంటూ వచ్చింది, వాడెవడో దారిలో పోతే చెప్తే వచ్చింది, క్రైమ్ జరిగిండొచ్చు, జరగకపోవచ్చు, ఏమైనా ఉండొచ్చు. జీడీకి బేసిస్ ఏమి? పోలీస్ మాన్యువల్ 1939. FIR కు బేసిస్ ఏమి? CRPC 1973. So ఈ కాన్ఫ్లిక్ట్ బిట్వీన్ ది సుప్రీమసీ అథెంటిసిటీ ఆఫ్ జీడీ అండ్ FIR వచ్చినప్పుడు ఏమి ఇంటర్ప్రిట్ చేశారయ్యా అంటే FIR prevails because it is a statutory application. Police manual is an administrative instruction. Therefore, you cannot have the supremacy of GD over the FIR. FIR is always. So GD అక్కడ ఏమొచ్చిందంటే another thing, నేను FIR రిజిస్టర్ చేయక్కర్లేదు, జీడీలో కూడా నేను రాస్తాను నాకు నచ్చితే రాస్తా. ఇన్ ద సెన్స్ సాటిస్ఫైడ్ దట్ దేర్ ఇస్ కమిషన్ ఆఫ్ ది అఫెన్స్, ఐ విల్ రికార్డ్, అదర్వైజ్ ఐ విల్ నాట్ రికార్డ్. Is that liberty, that laxity is there in the police manual as to entering in GD. Whereas the same thing applies because the details in GD, details in FIR register are same. So I apply the same analogy as to my duty for maintaining GD, for maintaining FIR. An argument was there, nothing doing babu. FIR is having greater sanctity. Your obligation to register the FIR is more sacred, more sanctified, more vigorful than that of entering into GD. GD is for looking your performance by your superiors, but FIR is looking by the public as to your response for the grievance and the crime against the society. All sanctified circumstances ఉంటుంది కాబట్టి you cannot equate this one this. So this one thing. Normally the other defenses you can, as far as FIR is concerned, delay. How many of you say that delay is fatal? I will come to your question after this answer. How many of you say delay is fatal? FIR లో delay ఉంటే FIR క్వాష్ చేసేయాలి, FIR చెల్లదు delay ఉంటే అని ఎవరైనా చెప్తారా? అయితే delay ఉన్నా పర్లేదు, ఎప్పుడైనా
Delay is fatal. Delay is fatal.
So it differs from case to case, circumstance to circumstance. Then what is the justification? Then what is the excuse? What is the excuse you can have for the delay in registration of the FIR? What is the excuse you can have?
There will be a column. What is the reasons for
Wonderful.
the
So there will be a column in the FIR, column number 8, more wonderful. So it provides, it stipulates for mentioning the reason for the delay in registration of the FIR, and that delay is justified. పోలీస్ స్టేషన్ పక్కన ఉంది, బాంబు పేలింది, నాకు 3 రోజుల తర్వాత రిజిస్టర్ చేస్తా అన్నాడు. పక్క ఊళ్ళో జరిగిన ఎఫ్ఐఆర్లో అర్ధగంటలో రిజిస్టర్ చేస్తా అంటారు. సో రీజన్, నాకు కావడానికి ఇన్ఫర్మేషన్ రావడానికి లేట్ అయిందా, పక్కన ఉండేదానికి, పక్క ఊళ్ళో గంటలో వచ్చేసిందా. సో దేర్ యూ కెన్ క్యాచ్. సో ద రీజన్, వెదర్ ద జస్టిఫైబుల్ రీజన్ ఈజ్ ఆల్వేస్ రీజనబుల్ రీజన్, నాట్ ఎ రీజన్ ఫర్ రీజన్ సేక్. So you can attack the delay, you can attack the reason, you can attack the justification in the reason mentioned in the FIR column provided for mentioning the reason. This is how the reason part affects. So always the delay is not fatal, but delay creates
suspicion.
Doubt.
Delay creates
Doubt.
Wonderful. Doubt. Benefit of doubt. Doubt. Another qualifying adjective, reasonable doubt. When it creates a reasonable doubt, then you can seek for acquittal. So that leads to circumvention.
Sir, electronic communication.
Fine, I am coming to that. Now 154 does not speak about the electronic registration of FIR, but 173, now the latest provision, is also contemplating the electronic communication of FIR. So mail istaru, FIR istaru. Mail lo communication police station mails and unnai. Mail lo commission of cognizable offence vachindi. Register cheyalana leda is one thing. It has to be registered. But the rider under the 173 is that within 3 days the signature of the informant is to be obtained. 3 days time is given. It is again interpretation. The informant has to sign in 3 days. Signature of the informant is to obtain in 3 days. Whether it's on signing in 3 days. More interpretations possible in 173 FIR is to be registered on signing within 3 days. Signature is to be obtained within 3 days. Informant has to sign in 3 days. మూడు కాలుగా కూడా అభిప్రాయాలు వ్యక్తమయ్యాయి. మేము ఓపెన్ డిస్కషన్ చేస్తే దీని 173లో ఉన్నటువంటి ఎలక్ట్రానిక్ కమ్యూనికేషన్ రిజిస్ట్రేషన్ ఆఫ్ ఎఫ్ఐఆర్లో సిగ్నేచర్ ఇందాక ఫస్ట్ క్వశ్చన్ అడిగాను. వెదర్ ఇన్ ఆల్ కేసెస్ సిగ్నేచర్ ఇస్ నెసరీ అంటే మైనర్స్ అన్సౌండ్ ఇన్సేన్ వీళ్ళకి సెకండ్ సమ్ ఎగ్జంప్షన్స్. Now in case of internet communication and electronic communication, FIR is registered and the person is at America. He has sent the mail and now he is not there in India. He has to come, means it may take a flight and other thing, it may take 1 or 2 months even. Then in that scenario, what is going to happen is a challenge. In the process of our journey, the law will develop how it is to be. Maybe digital signature, maybe signing before the embassy there. These are all the things, future inventions, they are possible. We can wait and we have to wait and see as that. But as far as the informant is reachable, his signature can be obtained by going to him or asking him to come. He can come. On signing within 3 days, FIR is to be registered is what 173 says. Sir, you are referring to something, please.
Zero FIR, sir.
Zero FIR, I will come to that. Fine.
It is not familiar in here.
Fine. Wonderful. I appreciate that.
Registered nearly 230 cases. Zero FIR. Where they got transferred the cases to.
Yes. Thank you for the fee. The point I might have skipped. Zero FIR is the concept which we have seen under the recent DNSS. Even prior to that, zero FIR was there. Zero FIR was there under administrative instructions. What is zero FIR is and what was the earlier experience is. మున్సిపల్ కోర్టులో వేయాల్సిన సూట్ను జిల్లా కోర్టులో వేశారు, నాకు సంబంధం లేదు పోనీ రిటర్న్ చేశారు. సూట్ సివిల్ కేసుకు కంపారిజన్ తీసుకొస్తే నేను ప్యూర్ వెజిటేరియన్ కాబట్టి నేను సివిల్ నుంచే స్టార్ట్ అవుతాను. నాకు నాన్ వెజిటేరియన్ ఇచ్చారు సబ్జెక్ట్ సారు రామారావు గారు. పర్వాలేదు, టేస్టింగ్ అని చెప్పకూడదు, నేను ఐఎమ్ టేస్టింగ్. సో ఇక్కడ జీరో ఎఫ్ఐఆర్ నా పరిధిలో లేదు కాబట్టి యూ గో టు ది పోలీస్ స్టేషన్. వీ హావ్ సీన్ సో మెనీ మూవీస్. కాకపోతే బ్లడ్ స్టేన్స్తో వస్తారు, రిపోర్ట్ చేస్తారు, నా పరిధిలో లేదు, వెళ్ళిపో వేరే పోలీస్ స్టేషన్కి వెళ్ళిపో, ఈ లోపల చచ్చిపోతాడు. చాలా సినిమాలు చూసే చట్టం చేశారేమో. ఇందాకే చెప్పాను కదా, రక్తం మరుగుతుంది, నా మిత్రులు రక్తం ఇస్తాను, నా కుటుంబం రక్తం ఇస్తాను, కవిలు వీళ్ళ భావోద్వేగాలు చెప్తే ఆ భావోద్వేగం ఏదో రోజు చట్టవేగం అందుకుంటుంది. సో దట్స్ వన్ థింగ్. సో నౌ దిస్ రిజిస్ట్రేషన్ ఆఫ్ ఎఫ్ఐఆర్ మధ్యలో ఏం చెప్పారంటే జడ్జిమెంట్లో కూడా ప్రాక్టీస్ కూడా అడ్మినిస్ట్రేటివ్ ఇన్స్ట్రక్షన్ కూడా ఏం చెప్పారంటే నీ పరిధిలో లేకుండా నువ్వు తీసుకొని ఆ పరిధిలో ఉండేటువంటి పోలీస్ స్టేషన్కి పంపించు. దేర్ ది ఇన్ఫర్మేషన్ వాజ్ రిసీవ్డ్ అండ్ ది ఇన్ఫర్మేషన్ వాజ్ ట్రాన్స్మిటెడ్. వాడికి నువ్వు ఇన్ఫర్మేషన్ తీసుకొని పంపించంటే వాడి పని వాడు చేయడు, పక్కన పని ఎందుకు చేస్తాడు? ఆయన నెత్తి కింద పెట్టుకొని పడుకుంటాడు, దీంట్లో తక్కువ ఉంటాయి కాబట్టి చాలా ఎక్కువ ఉంటాయి. సో దాన్ అగైన్ ది ఇష్యూ హ్యాస్ కమ్. సో నో you sending the same paper, okay, you may send, you may not send, just enter in your register FIR register that is contained to so and so police station, register it, that is zero FIR. అయితే జీరో ఎఫ్ఐఆర్కు స్టాట్యూటరీ శాంటిటీ లేదు. హౌ ఇస్ ఇట్? ఒక జ్యూరిడిక్షన్ ఒక జ్యూరిడిక్షన్కి ఎలా వేస్తారు? మందులు కావాలంటే రైతు బజార్లో ఎట్లా వెళ్ళి అడుగుతారు? ఇలాంటి ఆర్గ్యుమెంట్స్ కూడా వచ్చాయి. నో ఏం లేదు, పోలీస్ స్టేషన్ యూ కెన్ గో. Now the FIR can be registered irrespective of the jurisdictional embargo, and then the FIR registered would be transmitted to the concerned police station by the police. This is what the zero FIR. That's fine. So from police station, complainant will submit the FIR in NET, police will register, police will send to magistrate in NET, and signature part obtaining that takes place as the physical record follows. Then thereafter the charge sheet also will be filed. Charge sheet also will be filed in electronic form is what you see the provisions. If you see the provisions 193 which is parallel to 173 of the existing CRPC, even charge sheet can also filed in electronic form. Then how it will be consumed, how the process, how the practical papers and how many papers are to be supplied. ఇంతమంది 20 మంది అక్యూజ్డ్ ఉన్నారు, ఒక ఎలక్ట్రానిక్ ఫామ్ లో పంపిస్తే వాళ్ళందరూ కాపీలు ఇస్తారు. ఇద్దరు ఆల్ ప్రాక్టికల్ ఛాలెంజెస్. దే విల్ బి వర్క్డ్ అవుట్, దే ఆర్ బీయింగ్ వర్క్డ్ అవుట్, దే ఆర్ ఆల్రెడీ అడ్రస్డ్. Physical form lo kuda veyali. Mere sending of electronic form is not sufficient. It shall be sent in physical form also. As many copies are necessary for sending to the accused, physical forms are also will be same. So that is another scenario I think. So this is what I think I have. Trial set. These are quite trial set. So now, have you heard of successive FIRs and second FIRs and multiple FIRs?
Yes, sir.
Sir, please, sir, you want to say something? Just you can relax later. So fine. So, multiple FIRs is one thing. Successive FIRs is another thing. Two FIRs are on the same incident is another thing. Have you heard of all these things?
Yes, sir.
Some of you might have seen that also. If you have any experience on that, I'll be happy if you share your experience on that. Multiple FIRs or successive FIRs or two FIRs in respect of one matter. If so, what is the situation? There can be two FIRs in respect of one incident. Sir?
Multiple FIRs you can say.
Second one? Second one will be treated as 161. So you have reasonable exposure to the point. ఇందాక చెప్పిన స్టేట్మెంట్ ఎగ్జాంపుల్ ఇచ్చాను కదా. I greeted a Pakistani national, my friend, that Independence Day, and I said about 370 article that not one at Kurnool one FIR, at Vijayawada one FIR, at Visakhapatnam one FIR, at Nellore one FIR, whoever to the matter has been circulated, in all stations the FIR is registered in respect of the same incident. Can it be said as multiple FIRs of same incident?
Yes, multiple FIRs.
Multiple FIRs of same incident. Multiple FIRs of same incident. Is it permissible?
No.
Not permissible. But how do I know at Vijayawada police station that the complaint is already given at Kurnool? So then for this purpose, consolidation of FIRs and to the earliest place or the comprehensive place where the effect is there, all FIRs are to be brought there. The judicial intervention, High Court will interfere and say that all FIRs are to be brought at one place and one matter can be tried. The other things will become the ancillary thing is one. So I and my friend Garu, President, we fought something. And I am annoyed by Garu saying something and gave a report. Garu also annoyed and he also gave a report with regard to same thing. I gave it at 10 o'clock, he gave it 10:30. I said that he begged me with the stick and he said that I begged him with this marker, this pointer. Fine. Which has happened first, which has happened next is okay. Two things have in fact happened. Now whether the two FIRs are there or only one FIR shall be there. Two FIRs can be there. So genesis of incident may be there, but the effect of incident may have multi effects and both may be aggrieved. But here the another point is what made him to beat me and what made me to beat him. He said something, I said something. Who said first? Who said first will become who? Who said next become who? Who said first become the aggressor? Who did something will become the aggressor? Who has provocated the other? In defense, I may do something. In the process of defending myself, I may throw this. Or in the process of defense, he may throw a stick which is in his hand. Then it's a defense and it's an aggression. So aggressor and defense, both a case and counter case is also possible. And case and counter case, if you come across, my FIR is registered first, though my case is true, I say. No, he has managed and got his FIR first release. However, my case is true. You will go with whom? Whether the registration of FIR in first is going to be a merit, or the registration of FIR and content of the FIR is going to be the merit.
Content.
So the registration does not, the time of registration is not going to be the criteria or a matter for any consideration. Only the content of the material is going to be the consideration. Fine? So now, delay in FIR, I was referring to, creates a doubt. Whether in respect of accident cases, Prashant sir has to guide. The number of cases, the delay will be registered with them. The principle, be it an accident case, be it any case for that matter, whether the registration of FIR is important or what is important?
Saving the life of the person is the important.
Golden rule.
So, treatment to the victim, rescuing the victim is important than registration of FIR, giving of complaint, all that things. So whenever you come across in a situation, so these debates at this point you please bear in mind. Evidentiary value of FIR. FIR is whether a substantial piece of evidence, whether it can be whole or soul.
No, sir.
Substantive piece of evidence.
It can be whole or soul. It is corroborative.
Yes.
Substantive.
Whether FIR can be used for both corroboration and contradiction, or it can be for only contradiction, or it can be for only corroboration.
Corroboration and contradiction.
Both corroboration and contradiction, fine. Can I have, what is the difference between corroboration and contradiction? If I already covered in 2 days, I don't venture to go there. If not covered, somebody may let us try to venture difference between corroboration and contradiction. Is it covered?
No.
Any feedback, any thought on corroboration and
Yes,
contradiction?
I thought, sir, I did not go into the law. Corroboration means it supports the case. Contradiction means it's against the...
Destroys, sir. Contradiction is a destroy, create the doubts.
Yes, sir.
It's going to help to decide the veracity of something is a contradiction, which is going to help is a corroboration. So FIR can be used for both corroboration and contradiction by whom?
By defense and
By-
Whether the accused will use it for corroboration.
Yes.
Prosecution can use it for only corroboration. Whether the prosecution can use it for contradiction.
No.
So accused can use it for contradiction. Prosecution can use it for corroboration. Accused can use. What is the other statement that we use it for corroboration? 161 can be used for corroboration. Whether 161 can be used for corroboration?
Contradiction.
Anybody say that it can be used for corroboration? 161 corroboration use చేయొచ్చు అనే వాళ్ళు ఎవరు ఉన్నారా?
Contradiction.
ఎవరు ఉన్నారో ప్రాబ్లం ఎప్పుడైనా మా జడ్జెస్ యూజ్ చేసి ఉంటారేమో. అప్పీల్ గ్రౌండ్ ఫస్ట్ గ్రౌండ్ అదే పెడతారు. 161 మీద కన్విక్షన్ ఇచ్చారండి, ఎలా ఇస్తారండి, అసలు 161 మీద కన్విక్షన్ ఇవ్వడానికి లేదండి అని చెప్తారు కదా. సో 161 కెనాట్ బి యూజ్డ్ ఫర్ corroboration. 161 is there for only contradiction, that too by the accused only. Fine. Now, evidentiary value of FIR is certainly an important piece of evidence. It is not a substantial piece. It is to some extent substantial piece of evidence. It is an important piece of evidence, but it is not whole and soul. You cannot completely rely, you cannot completely decide on FIR. Only one case where FIR can be 80 to 90% can be relied in the NVAT cases. Because of section 470, rule 476 of AP Motor Vehicle Rules, which says that FIR can also be the basis for decide.
Yes.
This law is there. 176 of MB Act said and 476 of Motor Vehicles Rules said that it can be used for awarding the compensation, not for culpability. But for deciding the entitlement of the claimant for compensation, FIR can be used is what? Motor vehicle rules, yes. Otherwise, by itself cannot be the complete basis. Hope I am. Next. So, if I go like this, now probably I think there are so many things, not many things. As I said, it's a ocean. It's going to be a marathon. If we go like this, and now 12:30, Brother Justice Garu has also come. And as I said, that tea break, snacks during tea break, and your written plan are all there. If I stand more, I will be doing contempt of you all. So I want to just share that with my friends, and they will add something what they thought of, and you will also contribute something, so that the actual designed program of some kind of interaction also is possible. Many good friends are there, including my lord. So we'll have, with the permission of all of you and the president and others, I take a pause here. Not that it's not there, but positive of fact is there. Thank you one and all.